Hello, everybody. Welcome to our special needs trust planning session today. My name is Maggie Liu with Bordeaux Wealth Advisors. And here with me, I have Unifia here as well from Bordeaux to help us monitor the event today. And of course, the speaker, Michael Lee from Rui Attorneys. Michael and I, we have a lot of mutual clients together. So a little bit about Bordeaux is we are a independent wealth advisors, and we holistically manage clients' financial matters, wealth management topics, you name it. And oftentimes, more than what I expected is the special needs planning conversation topic is more than I think shows up in the conversation. So we put this session together with that in mind to make it educational and also give you a comfortable space to think this through. If you have family members or yourself, a friend or family that has this challenge or planning needs that they have, we will record this session and also you'll feel free to share the information that you got from here today. With that said, I'll hand it over to Michael Lee, the attorney today, and he also is a law professor. So I like his presentation that is very educational and also very, I think, bring it down to a level where people can relate and understand and help them make a decision to move forward, to take actions. So, Michael, why don't you introduce yourself a little bit, and then I'll hand it over to you. By the way, there is a Q&A box down below, and feel free to send in questions throughout the presentation, and we will try to answer it towards the end or in the middle of it if it's actually just go by where Michael is going to present anyway. So feel free to send in the question to the Q&A. Thank you very much. Go ahead, please, Michael.
Oh, well, thank you, Maggie. That's a great pleasure to get the introduction. And I hope you didn't oversell it. There's said, oh, there's Michael Lee. He's terrible at speaking. And then I can overshoot that. But I'll try my best here. So I'm going to share my slide deck so we all can have some notes, so to speak. I'll put it into presentation mode here. So what we're talking about special needs planning. And we're going to walk through a number of things for thinking about how to plan for loved ones that may have a circumstance that requires some additional thought beyond perhaps ordinary estate planning. There are other parameters, other things in play. So, a little bit about our law firm. So, RUI Attorneys. So, Mike Lee, Xiaowei Lee. I'm one of the attorneys. So, of course, just a little bit about me. Santa Clara School of Law, now teach at Santa Clara School of Law. Have been there a good long time. Also chair of the Board of Legal Specialization for the California State Bar. I've been practicing estate planning and estate tax for perhaps too long, so over 20 years now. And a privilege of practicing in this area is really helping people solve problems to make things better in the future. One of the things I like, I started practice, I started as a criminal prosecutor, litigation attorney, often, so there's maybe one could argue making things worse. Now my practice is making things better, and that's the most exciting thing for me, and that's what we'd like to help on. So a little disclaimer, this is for informational academic purposes. This is like sitting together like at the law school to think things through, get the thoughts going, to puzzle things out. But please don't take notes and then say, Mike Lee told me exactly to do this, and I'm going to now do it myself. Let's not do that because each case there may be some angles that we didn't consider. So this is for educational purposes. If you have anything specific, reach out to us and we'll help you from there. So what are we thinking about? What are we talking about? Is we're thinking about why should families plan for a loved one with a disability? This is a little bit of a different thinking from ordinary estate planning, where ordinary estate planning, sometimes we're thinking, okay, we're just take care of me and then pass the baton to the next generation and they'll take it from there. And that's all I'm thinking of. I say, we'll pass the baton and it's, their assets and their problem from then on. And when we think about planning for a loved one with a disability, with a special need, with special health needs, a variety of things, there's more to it. Is we're thinking, well, actually, I'm quite critical, me, in this person's life, financially, emotionally, for advocacy. I'm quite critical, but I'm a human being, and my time will not be forever. How do I transition to the next generation? How do I pass the baton when the person I'm passing the baton to is going to need some help carrying it? And it's going to need to be done with someone. And the things that we're thinking about is persons with disabilities are now living longer and living well longer. That's excellent. That's wonderful. But now I have to consider their lifetime is going to be substantial and be the same as perhaps siblings. But public benefits are often needed to supplement this for lifetime needs, for medical care needs. And sadly, healthcare costs, as we see, continually continue to rise. And because of these significant costs, these expenses can quickly zero out even a significant inheritance. So there is some tension here. And even with public benefits, the public benefits generally provide only a subsistence level of care, only really a level of care of the minimum, to keep someone alive. Extras, and again, I put it extras, things like transportation, accessibility modifications, activities, all of these things. This needs special supplemental planning. The ordinary programs do not have something there. So we have a need to say, well, okay, we want to supplement care with the public benefit system. And we need to do the public benefit system plus. We need plus. So we need to balance these two things. In addition to this, we have to be very careful with poor planning, because poor planning can lead to disqualification from benefits or inefficient use of the inherited funds. So we want to balance these things in our planning. So what are the objectives? There's a lot of objectives with this kind of planning for a special needs loved one, is to provide for of course, the financial and personal care for the loved one with a disability. We want to do this. We want to provide for, financially and for personal care. We also want to be careful, like we mentioned before. I don't want to provide for them in a way that disqualifies them from a means tested entitlement benefit. So if they are entitled to a benefit, but it has means testing, this inheritance that, let's say, particularly could be painful or troublesome, of this inheritance of $250,000 or whatever it is, well, that will disqualify them from the entitlement benefit in some situations. But it's not enough that one's going to live the rest of their life, not in the year 2025. Maybe in 1965 that would have gotten them pretty far, but not anymore. The other thing that is also critical, I'd say, is the softer side of the special needs planning, the legal planning, is establishing a reliable system that can perform the above over a long period of time efficiently without straining relationships. This has to be sustainable because, as we mentioned at the beginning, persons with disabilities or people with special needs are living longer and living, like all Americans, are living longer, living well longer. And so we have to plan for a longer time horizon. And just saying, well, there's, X amount of money there that will sustain it. It's like, well, okay, X amount of money is one part, you know, care, so it doesn't disqualify for benefits. That's one part. But now, how is this going to be administered for 60 years? Or how is this going to be administered for 40 years? Do we have something sustainable that works? So, what we're talking about, this is very, very rough, and I'm going to not dive deeply into the public benefit system because it is, number one, it's quite complicated. It's a little bit of dry topic, but what I will outline here is what we're concerned about are sort of what's on our left and the right here is first off concerned about the means tested public benefits programs, the supplemental security income, Medi-Cal, in-home support services. Those programs tend to be, well, I should say those programs are means tested. You can be entitled to the program, receive an inheritance, be kicked off the program, spend out the inheritance, and then go back to the program. You don't want to do it that way. That's super inefficient. You would want to maintain qualification for the means testing. In the middle, we have the public entitlement benefits, SSDI, and Medicare. Those ones are entitlement benefits. You won't necessarily have the same problem with an inheritance for those. And then you have other benefit programs that vary state to state. California, Washington, there's a little bit of variation on these. California, CalFresh is our food stamps. It's colloquially called food stamps, but are basically our food assistance program. Qualification for that. Section 8 is colloquially is the program for housing, supplemental housing benefits. So it's basically the things on our periphery here, the means tested benefits and the other public programs that we're thinking about, and we really want to maintain qualification for both of those. So that's what that's our challenge in terms of the sort of legal financial part, is we want to maintain qualification there. So I'm going to jump into something perhaps as a lawyer way of thinking about it, of some things that I would say we generally don't want to do. So I'm going to give you, in a sense, the wrong answer or problematic answers first before we jump into the third party funded special needs trust. And these are the ones that are the not recommended ones. And these are the not recommended ones, but are ones that I see very, very, very frequently. And it occurs either one is not familiar with planning, or things happen quickly, or there's perhaps some bad planning or issues that occur. So we'll outline a few of these. One of the first problems that occurs for both facing special needs persons or facing just ordinary estates is outright inheritance passing without a will or trust, passing without an estate plan. So if there is an outright inheritance, there's a couple of problems. This is generally done when there is no estate plan in place, there's no trust, and there is no will. So in those situations, you have to have a number of things to administer the estate. So in the case of when the person passes away, you'll often have to have a probate administration so that the assets pass from generation 1 to generation 2. That's costly, that's troublesome, because you will have to, particularly in California, you'll have to go to court. Generally, you'll need to have a lawyer. It charges a percentage fee. And because of all of that, it is quite inefficient. This gets even worse when you have a special needs person, because, okay, we solve the probate, we get through the probate, and they say, okay, son is the heir. Well, he's a special needs person. We just got through the probate court case, and then they tell me we're going to have another court case. We're going to have a conservatorship, a limited conservatorship for the beneficiary, because the beneficiary cannot can of course inherit directly, but they cannot manage their funds because of their particular disability. So now I end up with a limited conservatorship of the person's estate, and I am basically in court forever. I'm in court to administer the parent's estate, and I am in court for the entire lifetime of the conservatee, because the court will monitor and account for the conservatee's assets via the court system. And that is quite time consuming, quite burdensome, quite inflexible, And it is really not the ideal way to go. And in many cases, because it is the outright inheritance, it's going to cause the loss of SSI and the loss of Medi-Cal. So, in addition to all of these significant administrative costs, it also leads to an actual bad result. It leads to the result that the person had entitlement to these benefit programs, perhaps was on these benefit programs while the parent or the other person was living, but then because of the inheritance gets kicked off, and then the inheritance gets diminished because of the administrative cost expenses. Not a good way to go. Better way, do estate planning, and then do estate planning, as we'll see, where we consider things like special needs trusts to make the planning better. So outright inheritance, not good. Next one down is the person says, well, I did the estate plan. I did the estate plan. I have an ordinary revocable living trust. It's 50% son, 50% daughter. Okay, for 50-50. For son who has special needs, do you have the special needs provisions built into the trust? Is it designed where that trust, his share is a special needs trust? Oh no, it's just a simple one. I just got off the internet or something. It's just we filled in the names and just said print and printed and signed that. I said, okay, well, it says 50-50. What does it say for each person? It says outright 50-50. Providing they're over 18. Well, that's also not good. Okay, how's it better than outright inheritance? Well, we got rid of the probate problem. We don't have the probate problem, but it says outright if over 18, and there's no provision there regarding special needs planning to make the trust a special needs trust that has the restrictions that enable continued benefit of SSI or continued benefit of Medi-Cal. Is that there? No, it's not there. So what does this cause? What we have this problem of, if it's outright, do we need to have the conservatorship? Well, technically we do, because it's outright. It's the same result as the outright inheritance. It's just via the trust. We're getting kind of the same answer. What do we usually have to do in these situations? Usually we have to go to court as part of the trust administration and say, whoa, there's been a big mistake. Can we try to do a special needs trust now? And then, as we'll see in a moment, we'll say, can we really maybe try to do a third-party special needs trust court, please? Will you let that slide? Because that's going to be way better for the person. Or if you get a particularly strict court, they'll say, no, it says outright, it vests in the person, and now you're going to do a first-party special needs trust. Say, okay, that's a little bit better. I can live with that. But the first-party special needs trust has Medi-Cal recovery. What does that mean is that if the disabled person seeks access to Medi-Cal, particularly the Medi-Cal living situation, at the end, when the person passes away, the beneficiary passes away, Medi-Cal will basically claim reimbursement. It says, okay, we put out for all of this. Now it's time to pay the bill. Third-party special needs trust wouldn't have that. And we'll talk about that when we go forward a little bit. So ordinary revocable living trust it's better than nothing. We see it's in number 2 on the list. It's better than nothing, but there are some problems because it's not tuned to the situation. And I tell this story, and we'll get into it a little bit more. When I was in college, my college job, but actually sort of family traditional job, we were tailors, and we did it was a dry cleaning and tailor work. And I joke with my clients and I say it's the same thing that I do now. I make things fit. And the problem with the revocable living trust is it's basically saying, you're a 46 long, right? I say, no, I'm a 40 regular. And they're like, you get your arms into it, close enough. It's better than not having a coat, but it's not fitting right. It doesn't fit our situation. We'll see in a moment how you can add the special needs trust module into the revocable living trust. Now we've got it, we have the Italian suit here that's tailored very finely. Okay, we have special needs for son, takes care of him. Daughter, we don't. And we'll see some other things, how this works together. A couple of other items that we see frequently. The transfer to minors account. Transfer to minors account. This pays at 18. This is not a good vehicle for persons with special needs. Star by this, contrast this to ABLE accounts. ABLE accounts can be good. ABLE accounts with a special needs trust can work in tandem, and perhaps we'd be using these, and each one of these together makes the other one better. Those work better. So this is more of a distinction issue of just make sure that if one is going the route of an ABLE account, ABLE account, that's that. And one doesn't say, yeah, I guess it's the CUTMA account or UTMA account. Yeah, it's the same thing. Not the same thing. Massively different. They will do different things, and one can cause disqualification of benefits. The transfer to minors account can cause disqualification of benefits. Last two are more situations with regard to design and structuring. So with the design and structuring, I do see some situations where people will design and they'll say, well, I have your child with special needs, I have the child without special needs. What I'm going to do is I'm going to just disinherit the child with special needs. They will receive nothing from the estate. They'll be specifically disinherited. And I'm going to allocate that to others. I'm going to allocate that to the other child. So I'm going to put that to the other child. So the problem with this, and these go hand in hand, the disinheritance and the collateral distribution, which is basically giving to another person. This is quite risky. This is something where we have to be very, very cautious with this, because if I give to daughter and son is left entirely disinherited, I do rely on daughter to take care of him. What if she doesn't? Key thing that I encounter a lot is we say, oh no, she'll do it. She's a great daughter. She'll do it. And it's like, how well do you know her husband? Because he's maybe going to have some problems with this, or if it's the reverse, how well do you know his wife? Maybe this is going to cause some friction with them. One of the concerns with this disinheritance collateral distribution system is we are putting quite a bit of pressure, of expectation on the other child. And is that, again, we're thinking from our earlier thought of, is this sustainable for 45 years? Can this go all the way? Maybe not. Maybe this is not the best way to do it. The other risks is if the inheritance is all to the other child, it is subject to their creditors. So if the child without the special needs has a tax problem, has a debt problem, has a liability problem, that money's exposed. The idea of saying, well, I inherited all from my parents, but then it was always kind of understood that it was, half to my brother, IRS don't take it. IRS would say, oh, that's funny. But yeah, we're taking the money. If I hit someone with my car, that's gonna get oh yeah, that's an interesting thing. You probably should have wrote it down and segregated the accounts, because if it's all in your account, we're gonna take it out. So it's not safe. It's not safe from risks that the non-special needs child has. Here's what a real case of mine. They can say this. They say, "Oh, Mike, that's never going to happen." My son, and actually, this was what the client said to me. It wasn't a special needs context, but it was an asset protection context. They said, "Oh, that's never going to happen to my child. My child's extremely elite, well educated. My child's an oral surgeon." That's a super, super high risk profession. They get sued all the time. They operate on people personally out of a private office with assistants. That's just flaming hot of liability. So actually, that idea of safe, I'll give it to the elite child. Oh, well, we got to think about it. Not necessarily good planning. We had our heart in the right place. We were trying to protect the benefits of the special needs child, but strategy, it's the logistics of it. And even the strategy was more or less correct, but it's like they say, the armchair generals talk about strategy, real generals talk about logistics. Real planners talk about the logistics. How does this really play out? And creditors a problem. Same problem of what happens again, it is in the other child's account. What happens if they pass? Is if they pass, if it's community property, if they've all commingled it, it goes to the surviving spouse. If they've kept it separate, it's going to go half to the surviving spouse, and it's going to go other half to the children. If there's more than one children, it's going to go two-thirds to the children, or based on their revocable living trust. So we have this potential problem of, did that child then do estate planning? What's their thoughts? Did they remember Uncle John, or was there some issue there? Problems. Divorce, if it gets commingled and it's commingled for years and years, and the child didn't do a good job after the inheritance of keeping separation between these two, it could be captured by the other spouse in a divorce. So this is the problem of a disinheritance and collateral distribution, is that it really relies a lot on that person personally. It relies on their personal finances, and it subjects it all to their financial or their family dynamics, of which I might not have control, and I probably don't have control of. So, not super safe. So, not what we should not do. What should we do? What is a special needs trust? So, special needs trust it's a large term, and it encompasses a number of different things. And we'll see in a moment. We're really talking about just one thing. Why is because if we were talking about all of them, we would be here a couple of days. It gets a little complicated. But what we're talking about really is the third-party funded special needs trust as a type of trust, or, and this is critical, or a module built into an ordinary revocable living trust. It can be designed as part of the ordinary revocable living trust. It won't make that whole trust a special needs trust. What it is saying for this beneficiary's 40% or 50% or 20% or whatever it is, that's going to be held under special terms, under this special long-term trust. The trust for sibling or the other siblings or other beneficiaries, that will not. That will be under different terms, maybe more outright style terms, because that fits the person. And the purpose of the special needs trust is to provide funds to supplement public benefits without interfering with the public benefits, causing disqualification. So the public benefits laws control the establishment and administration of the trust. So that is sort of blended together, the law of trust planning and then the public laws for qualification for the benefit programs. And a special needs trust done properly preserves the eligibility for SSI and Medi-Cal. That's, of course, our primary objective. But the objectives 2 and 3 are also critically important, is appointing a lifetime management team for the beneficiary's finances and care, and really thinking through of that, okay, we'll have the successor trustee, but how are we going to do this, again, in a long-term way that fits the people in the right way? And a special needs trust can provide advocacy for the beneficiary, and so that the support system that the parents or others have established can continue when perhaps the parent generation is not here, and continue in a way that is sustainable and lets the people involved in the plan be their best selves or be their best role. So oftentimes we find, with a special needs person, what they need is, care and compassion and their life to be organized financially. That's what they need. And oftentimes we find with the sibling generation is they say, I am totally great with all of that. Compassion, care, love, that's literally my blood brother. I'm not so good with the finances, though. I'm not so good, and not because I'm not competent or I'm not reliable. It's a big job. I got to keep track of all of this. I have to, I have to account and I have to call and I have to do this and that and the other thing. That's the part that, that I have strain. I like being my brother's brother. I don't like being my brother's accountant. I don't like being my brother's lawyer. I don't like being my brother's financial planner. I love being my brother's brother. And that's where we have good planning in terms of course, legal, the legalese of the trust. But we also have good planning of saying, let me be my best brother that I can be. You lawyer be the best lawyer you can be, and we're going to get an accountant who's going to be the best accountant he can be. We're going to get a good financial planner who's going to be the best financial planner she can be. And let us be the best at what we are actually best at. And this is one of the things that we see a lot with, we sometimes call it administration burnout, of people have been administering this and administering this and administering this, and they say, I have to deal with my life and my kids, and they're in private school and they're two different ones, so the calendar's not even the same. So I'm doing that. Plus I work, plus I have my spouse, and then I have to take care of John. And then John, I don't like this particular housing situation, so I'm going to take him out, and I'm doing so then I need to do all of that. Plus I need to do the finances. Plus I don't know what happened in April with the tariffs, but the market's down, so now I'm really worried because the trust isn't as filled as it used to be. That's too much. That's too much. That's you can't process that. Do the part where you say, I can do the part of being the brother. I visit him all the time. I know what's a good housing situation, what's not. Good. Advocate. Do that. And then phone call to the trustee and say, okay, we're changing the housing. Go call the other place, get the billing set up. We're going to do the accountant. Go arrange the monthly distribution. Do it that way. That is more sustainable. And this is just a brief chart of the different types of special needs trust, the different types of planning. And what we're talking about is the first line, third party special needs trust. Source of funds, where does the money come from? Where does the asset come from? It comes from anyone except the beneficiary, anybody except the special needs person, not their money. Hopefully we've been trying to plan so that funds go around that person. Who establishes it? Anybody except the beneficiary. Distribution on death of the beneficiary, it depends on the parents. So I could say for my son, for as long as he needs, and then after, it's perhaps he won't have children. After that, it will go back around. It will go back to the, his nieces and nephews, back to his sister. Or it will go to a charity that is a charity that matches, his life and honors him. I can choose all of that. Third party special needs trust, highly tailorable. The drop down, the first party special needs trust. I'm just going to put a star by this. This is different. This generally is funded by the special needs person from their assets, often because there was an accident, because I perhaps did not have special needs, but my disability occurred because of an accident. And then, of course, my family sued the heck out of those people as my representative, and I am entitled to compensation. That will go via a first party special needs trust. That's totally different. That's something that is a different conversation, different design of those. And very similar to the pooled trust. The pooled trust is a different kind of trust. It's generally done through a nonprofit or done through those vehicles. What we're talking about is the first one is the family, the parents, the grandparents, collateral relatives, brothers and sisters, uncles and aunts, those persons providing a fraction of their estate to the special needs person. That's what we're taking a look at as the third party version. The reason I emphasize this is because if doing research and looking at these things, be careful, because they sometimes the magic of the internet, they get mixed up, and people will say, well, wait a minute, it doesn't have to be funded by the special needs person. It's like, no, that's first party, you're doing third party. Well, wait, what about the Medi-Cal payback? First party, not third party. It's different. So I thought the court has to be involved, first party, not third party. So That's a significant distinction on how they're funded, how they're established, and then what happens to them. It's different depending on which one you're up to. So talking about the third party special needs trust. And as we mentioned, preserve SSI Medi-Cal, and it's designed to not give cash to the beneficiary, no outright gifts, and it's supposed to pay around things that are means tested by the beneficiary. So pay around things like housing or subsistence medical care. So it will pay for all of the things like, if I'm entitled to just ordinary doctor visits, okay, I'll have that. But they say, well, I need, for mobility, I need a wheelchair that is motorized and a little bit better than what's standard kit. Okay, great. Classic one that's not included in SSI or Medi-Cal is, well, okay, where I'm living, I need some disability modifications. The door swings at an angle that's not useful for me. Well, third party special needs trust, well, we can do that. The benefit programs won't be able to do that. So we're trying to basically everywhere where there's a gap, we cover. And in 2026, this is going to become even better. There's going to be basically more things starting 2026 that a special needs trust can fund, basically food. So basically you can start, you're not going to have any restrictions on supplementing a lot of their nutrition. There used to be a little bit of nutrition limitation there. Now that's going to go away. So the law is going in the right direction. And that's what the special needs trust, that's the purpose of what we're trying to do in a technical sense. There are a couple of ways to establish the third party special needs trust. So a lot of people say, okay, this is looking good. I'm interested in this. Here's another way where, again, careful magic of the internet of different ways to create these things. So it does not have to be horrifically difficult or complex at all. It's actually just done with a little bit of intent. And so for most estates, what one does is you create a module in your ordinary revocable living trust that has the special needs trust available for that particular beneficiary. And you can design in the revocable living trust, so you say, okay, son, he will have those provisions. Daughter, we don't need these provisions. We can even design that. I've had some families that say, well, I'm not really sure how things are going to turn out because my child is quite young. I don't know where his needs will go. Maybe his needs will diminish. Maybe his needs will increase. What if I'm stuck with a special needs trust and it's very inflexible? Not a problem. We can draft that special needs trust module that has provisions that if the person essentially does not require the special needs provisions anymore because their needs are not as significant. They don't qualify for those programs, perhaps. They are doing well, and they don't need the special needs provisions. This trust could convert to a general needs trust. It will still be managed by somebody else, a sibling or somebody else, but we won't have to have the special needs restrictions anymore. We can sort of release them. So this can be designed in a way that is very, very flexible. We also can design it in a way where we say, well, I don't know if one child maybe has special needs, my other child, I don't know. We can have standby third-party special needs that can kick in if we need it. That we say, well, we'll default to not needing it, but if we need it, it will come about. We can do a lot of designing to make this module available, flexible, easy to deploy, but not onerous in a way that we say, I'm stuck with this thing and now it doesn't really fit. Again, tailoring doesn't really fit us. We can make it flexible. It can work. So that's the first thing I recommend, module in the revocable living trust. The second one I really, really like, thinking about this, or using this with the revocable living trust to fund, is using life insurance. Life insurance is a very, very efficient vehicle for funding a special needs person or a person with a disability. It's very efficient estate gift tax. We could join us again when we talk about ILITs, irrevocable life insurance trusts. because if you combine the magic of the irrevocable life insurance trust with the special needs trust provisions, I, as a parent, can feel very comfortable that I say it will be this dollar amount and it will be income tax free. And structured with the ILET, it will also be estate gift tax free. And I know there will be X amount of money in that trust that's liquid cash that can then be used to take care of this person. Good planning, predictable planning, reliable planning. I don't have to worry about what if there's a market downturn. I don't have to worry about that. So this can work very well either as an irrevocable life insurance trust designed this way, or life insurance if the estate maybe is not so large, life insurance that folds into the revocable living trust. So we can do it that way. Last one, irrevocable living trust, IDGT style trust. This can also be usually used in larger estates for dealing with estate gift tax. But I've had some clients, sometimes older clients, like this irrevocable trust, is they say, I want the structure to go live while I'm living. So I want to fund this thing. I'm going to put some money into this trust, and I'm going to have, who's going to be the trustee. I'm going to have whoever's going to be the care manager, the accountant, the lawyer. I'm going to set this up, but I'm still here, and I'm going to watch how it works, and I'm going to fine tune it. And it's going to go live because it's already funded. It's going to start taking care of the person. I'm maybe a little bit too old. That's why I'm doing this, is because I need to pass the baton. But I also am here, and I'm going to exercise my opinions to kind of adjust this and modify this as it goes forward. So that can be good for the right estate. So these are all third-party special needs trusts, and they are different ways to deploy it, either in the revocable trust, via a life insurance trust, or via a full standalone irrevocable trust. So some design features for special needs trusts, just things to think about. The trusteeship, the classic, husband and wife revocable living trust to say, if I go, my wife alone. If she goes, me alone. After we're both gone, the kids 50-50 as trustees, and they divide it out. That's kind of classic. Not necessarily a good idea for designing for beneficiaries with special needs. The trusteeship will not be just a 1 year in and out thing. Parents go, and then basically I add up all the properties. I say, half to you, sister, half to you, brother, and I'm done. Now, a special needs trust is going to go on for the life of the beneficiary. So we need to have special considerations thought through of who's going to administer this. Is it going to be, let's say, sister at first to divide out her share, and then she'll pass the baton to a professional trustee, or it's going to be a co-trustee with another person? Have to think about that. Next thing to think about is this role of trust protector. This is sort of like a super trustee. This person can modify the trust and make certain variations of the trust. This is important, is that oftentimes when one is just a trustee, I am bound by the trust. I can't just do whatever. I'm bound to do what the trust requires me to do. So that is good because I have fidelity to the plan. But if we need to modify the plan, we'd have to go to court. But with a trust protector, we have a built-in safety valve that if we have to alter the trust or modify administration, that can be done in a non-judicial, non-court way. The other thing that can be helpful is thinking of a care manager for the special needs trust, of someone who is skilled with managing the particular care needs of the person in a sort of medical slash living situation professional. So that can be very, very helpful there. So as we mentioned, the special needs trust can be funded. The third-party special needs trust can be funded from anything, cash, stock, real estate. Life insurance tends to be very attractive for this. Just be careful on this. My overarching, question on this is, make sure the special needs trust is funded with an asset that is not a problem, an asset that is difficult. I had a client that was funding and said, okay, well, we're just going to do it, half and half. I said, okay. And said, oh, why, he says, it's easy, it's half and half, we'll do half and half. The person had a closely held business, a very complicated, closely held business. I said, we need to rethink this. This business, the closely held business, is so complicated. The business needed lawyers so commonly and so frequently. One of the lawyers of the law firm that you used to hire, you hired so that she worked for you all the time. Like, it's that complicated. Like, don't put an asset that is, there's often an instinct 50-50, but things like, a classic thing, I'm going to put a San Francisco multi-unit property in a special needs trust. Do you know how difficult it is to manage a San Francisco multi-unit property, a 5-unit pre-1978 property under rent control? And how unreliable the rents are? What if I get a bunch of bad tenants and we owe the property taxes and the special needs person needs the money, but the tenants won't pay and then we owe the property? This is not a good plan. This is not a good asset. We have a great special needs trust. We have the design all great, but we didn't fund it with something that was the right thing. So there's another level to this and a financial planning element of this, of saying, okay, I don't just need the structure, the paperwork of the special needs trust. I now need the guidance of how am I going to fill up this box with something that over, again, and we're thinking 45 years here, that this is going to be the right thing. A closely held business, a multi-unit property. Before we put that in there, we have to really think about how that's going to work, because it may be right structure, wrong asset. The other thing is to think about, in addition with we got the structure right, we got the asset right, is do we have the team right? Because again, this is going to basically be me for 45 more years, maybe longer. And I need, I say a team for this. And I simply call it family plus, because there is sometimes, we mentioned earlier, an instinct of saying, oh, daughter will handle it or son will handle it. And I go and I say, whoop, there you go. It's your challenge now. And that is overwhelming and it is inefficient. And what I think is every parent's fear is that this is going to drive a wedge right between the two kids or between my special needs family and the other family. And this is just going to this. And what's driving the wedge is the administrative minutia that drives everybody crazy. Did PG&E get paid? The credit card doesn't show it was paid. Did PG, am I going to get a fine from PG&E because I was late? That's a problem. Did the care home get paid on time because they charge a 2% fee if they're not? This is the thing that drives people crazy. Because how do we know? Because we all deal with this and it drives ourselves crazy. So imagine doubling this and doing it through a special procedure. Team, family plus, attorney, accountant, care manager, financial advisor, because again, trying to say, I'm managing my own retirement, my own finances, and then I'm managing an apparently they say irrevocable trust that I have to do. And then the accountant, or maybe I don't have the accountant, I read something on the internet that scared me about the tax bracketing for, I think, tax bracketing for income coming out of an irrevocable trust is taxed at a bad rate. Oh, wait a minute. I thought I should set up the portfolio for income. So I chose all of this, like those ETFs that provide a lot of income. Oh, wait a minute. Now either I keep the income in the trust, it's taxed at a bad rate, or I give it to the special needs person. Oh, but that disqualifies them from the benefit. This is where we start to fall apart. If we start to have the team and we say, okay, here's the trust, you're going to get advised for the taxes by the accountant, the attorney, the financial planner. So we're going to choose the right investments for this. We're going to have, let's say, the special needs trust in the ABLE account. That way we're going to be able to take them, we're going to get income. We're going to put the income in the ABLE account. That way we can flow the taxes over to the other person. It's going to, this is how it's going to work. And then the person says, oh, that sounds like a lot. I say, yeah, we do that. Yeah, that's over on your side. You come in, once a month, every 2 months, or quarterly. We double check the plan and we're good. That can last 45 years. Doing this ad hoc constantly That's quite challenging. So that is so the from formation, funding to operation, the cycle of the special needs trust. And I think I've hit the time. Pardon me for looking at the watch. I don't know if you've ever done the Zoom the Zoom seminar. I don't have a clock at the screen. For some reason, when you do the Zoom seminar, there's no clock there. So I'm always afraid that I overshoot this and I don't leave time for questions. Oh, this is a little bit about us. Of course, you can always get this, of course, just from Maggie and everybody with Bordeaux. But I want to just leave a little bit
Right,
of time for
right,
questions.
good on time. We have about exactly 10 minutes on the session here for some questions. So there is a few questions coming in. I think you addressed it in one of your slides, which is can special need trust be added to a already existing revocable living trust, or does it need to be set up at the same time? I think you mentioned that in one of your slides there. But we can go a little bit more detail on that. A little follow-up question on that, which I get a lot from clients or prospects we're talking to, is when should you fund the special needs trust? Is there a requirement or it's really case by case situation? Yeah.
And this actually is great. The two questions kind of have the same answer. The good news is the special needs trust provisions can be added to an already existing revocable living trust. So if perhaps my wife and I did a just our ordinary revocable living trust, and we didn't put those provisions in when we initially started the trust, no problem. We can simply amend and restate the revocable living trust as we normally would do just for an ordinary amendment and restatement. But as part of the amendment and restatement, we'd say we need special needs trust provisions for one of the beneficiaries or standby or whatever the design is. So for that, it's essentially one can always add it, and it does not does not cause some massive disharmony with the original revocable living trust. It's just a continuation of the revocable living trust amendment and restatement process, which we do all the time, or people families do all the time. If you have an old trust prior to 2010, people do amendment and restatements because the tax law changed. This is the same way family circumstances changed. For funding, it really depends on the kind that we're doing. If our estate plan is the revocable living trust plan, the funding is essentially just good revocable living trust practices, making sure everything's in the revocable living trust, or the revocable living trust is the beneficiary to assets. That will flow well. We don't have to do special funding then. We do have to do special funding if we are doing like the irrevocable life insurance trust or a standalone irrevocable trust. Then we have to think about special funding mechanisms then. But for standard plans, generally not necessary.
Can you touch on a little bit on the 529 ABLE? Because I think for some folks on the call today may not be too familiar with what it is and some of the changes and updates, perhaps after this tax extension discussion coming on the horizon.
Yes, so the ABLE accounts are very, very good options for, and I would say you often see them kind of working in tandem with the third party special needs trust. So who can use these? This is usually persons who are, as of now, were disabled before the age of 26. But this is going to change in the year 2026 to the age 46. So in the next year, we're going to have much broader accessibility for ABLE accounts. So if you've looked at it before and said, oh, no, there's a particular reason why I didn't look at it again, that's going to change. So that's good. Who can fund the ABLE account? Anyone can fund the ABLE account, including the person with a disability. So this we can see how this can sometimes connect with the third party trust. Is I have the third party trust and there's some interest income, there's some dividend. If it was held in the trust, it would be taxed at the trust tax rate, which is not so great. If I float it through to the beneficiary, it would be at a better rate, essentially. But I can't give it to him or her directly. Able account, put it in there, taxes, solution. That works well. Generally, the special needs person can only have one. That's fine. Who can control it is generally the person, if they're a high functioning person, sometimes they can control it, or the legal guardian or their conservator can control it. So the custodian of the account, the who inherits it, that can be designed. How much you can fund a year, it's generally the annual gift exclusion. So you can get 19,000. So this can be a good alternative to an irrevocable trust. You could do 19,000. If the person's employed, it can sometimes be more. There is a cap on these of how much you can fund. I think the cap is similar to the 529 cap, which I think is 529,000 in California. There is a funding cap on these, but there's no income tax on the tax earned in the ABLE account. So as we can see, this you want these together, this operating together with ABLE account, third party special needs trust. We can really get the best features of the trust, and we can get the best features of like a 529 account, or in a sense maybe like an IRA, but something that is more tuned, again, tailoring for someone who has special needs, and get good tax treatment for them.
I think we'll take one or two more questions. One here is it possible to have a special need trust in both revocable and irrevocable trusts?
Yes, yes. So you can absolutely do that. I would always say you start with the revocable trust first, because that's the big safety net. That's the big safety net under me, because I definitely want, if something happens to me, I want it to get sucked into the trust, and the trust for my special needs loved one, I want that to be under the special needs provisions. So start with the revocable. And the irrevocable are really just like irrevocable planning for estate gift tax purposes. As I say, classic one, say my wife and I, we're going to do a very large second to die life insurance policy, because that's how we're going to fund our son. And actually what we're going to do is we're going to change the distribution of the revocable, where it's going to be like 70-30 or 75-25, 75 to our child who doesn't have special needs, 25 for special needs child, and then the irrevocable trust, the life insurance, will be 100% for special needs child. Why? Because maybe I have a closely held business. I say I got to get that all to daughter, because my son who has special needs, that's going to be a mess. So that's common, where we're mixing. We have the revocable, irrevocable. We're changing percentage ratios, and a lot of it is driven by I'm trying to allocate the assets. Of these assets are better for someone to manage personally. These assets are more of a safe, sure thing, and are easier to deal with, and I'm trying to do that split.
Do you need to follow the gift exemption amount when you are funding a special needs trust?
Not a revocable living trust.
Mm.
So the revocable living trust, you don't have to do anything, because there's no gift during lifetime for the revocable trust. Irrevocable trust will work under the same rules as a revocable trust standard. No special filing.
Perfect.
So
Any last takeaway? I mean, a lot of time this is a very emotional topic, right? For a lot of people, family especially, they're facing the design, the challenge, and sometimes they don't figure out if this child of mine actually needs special needs care. Maybe they, going from minor to adult, there's a lot of changes, just like any adult child, right? For that, with special needs or not. Any things that you can suggest or take away for people who are going through this to relax and work with a team and professional, or what are some of the things you can say to the audience?
well, I would say is join the professionals early. We're here to help. I think it's odd to say as a lawyer, but I say most people who went into this is because I wanted to be in a profession that maybe causes more good than not. I know it's hard to say as a lawyer. It's easy to say as a surgeon, but it's hard to say as a lawyer. But we do, care about this quite a bit. And I think the thing is you come in, learn, get informed, understand the situation, and a lot of these structures, let's say the special needs structures for the revocable living trust, we can build such a structure in standby special needs provisions that don't apply to any particular child. It's simply built in. We call it standby special needs language. That's basically like an extra suitcase on a trip. If we need it, if we bought a lot of stuff, we'll throw stuff in there. If not, we don't need it. And it's always better to plan and not need it than to have an issue, a crisis, and say, oh, we probably should have planned. That tends to lead to bad planning. It tends to lead to excessive costs. It's not efficient. And like we said, you're trying to be the best you can be in the appropriate role. You want to be the best parent. You want to be the best sibling. The parts that are things of like, this is the accounting minutia that I don't want to deal with. Leave that to someone who has an economy of scale and can do it efficiently. That will make you be the best you can be. They are a good accountant. That's why they have a license and they make that their profession. Good, let them do that. I don't do my own accounting, because it's a hassle, and it's not efficient. Someone literally has software and all kinds of engines to do all of that. Great. Please, do that. I'm going to do what I do, and I think that enables one to really, our ultimate focus. We want to care for the person and have family harmony, and not have that be diminished because I have to keep track of receipts. Don't let that hinder the first part.
Thank you so much, Michael. We had just a little bit 1 minute over our time. So we will, feel free to let us know if you like a recording of this after this seminar. We will hope to do more and reach out to more folks that can just hear a piece of advice like this to kind of get their thinking, going. What do I need to do next? Like you said, you want to plan first. That will reduce the stress, not, react to it when it's already in a situation. There's one more question here. Oh, okay. We're all good here. Thank you so much, everybody. Appreciate your participating. Thank you so much, Michael. Appreciate your time here.
Oh, it's
Thank
a
you.
great pleasure, all. And then, yes, again, feel free, contact via Maggie if you need to talk to me. They know where I am. So, great
Thank
pleasure
you.
for the rest of the week.
All right,
Thank you so
thank you very
much.
much, Michael.
Thank you.